to introduce our first speaker this morning. Gillian Mawdsley is the Policy Executive and Criminal Law Secretary at the Law Society. She's a qualified solicitor and she's worked in a range of policy and practice areas, including within the Scottish criminal justice system for organisations like the Crown Office, the Scottish Legal Aid Board and the Scottish Courts and Tribunal. And she's also managed to fit in a wee secondment to the Scottish Government. She teaches in a variety of subjects of under and postgraduate level at universities, including Strathclyde, Edinburgh and the Open University. So it's my pleasure to introduce Gillian, and I'll hand it over to you. Thank you.
Firstly, thank you very much, Fiona, for that introduction, and thank you all for inviting me here to speak. The title of my talk today is Children, their 360-degree role within the Scottish criminal justice system. So looking about at your speakers already, and I'm slightly intimidated by some of the comments in the chat box about how brilliant yesterday was, and I hope today will lead up to that as well. I think some aspects of my talk will inevitably overlap with other speakers yesterday, such as Juliet and indeed Ian. However, I hope to bring some observations from a practical perspective. I don't bring solutions, I bring some thoughts, and very much welcome your response and feedback. And it's important that I set out some parameters at the start, that my views and observations and indeed experience comes from my role as a Scottish qualified solicitor, speaking from a criminal perspective and relating that to the role of the child. I do not in speaking represent the views of the Law Society. These will be my views, but hopefully there'll be some ideas for you to take forward. Some of you, as Fiona's referred to, know that I teach. And looking at the title of the talk, I wouldn't be that teacher if I didn't say, let's look at the key words. So the words I'm going to cover are child, Scottish criminal justice system, and then 360-degree role. So starting with the child, there are two quotes from American presidents that encapsulate how the criminal justice system should perhaps view the child. And I'll leave it for you for your justice quiz to work out from whom they come. They emphasize the child and the importance to society. And these are, children are the world's most valuable resource and its best hope for the future. And the second one, we may not be able to prepare the future for our children, but we can prepare our children for the future. So the law provides a framework. So pause for a second and recognize that legislation has moved on, reflecting society's changing attitudes towards the child. But as all good lawyers will tell you, you need to understand firstly what you mean by the word child. So a relatively simple concept, we might think. What is a child? The dictionary definition says it's a young person. I don't know how young you all are, though I feel pretty old this morning, and young is, of course, a comparative term. But that definition goes on to state, the law in either England and Scotland cannot be said to offer any single definition of the word. Various ages are defined as childhood, but all are under the age of majority, which they state is the age of 18. So traditionally, when we think of a child, it was perhaps in the context of historical employment or education, where the two, certainly in Victorian times, were inexorably linked. So again, back to our justice questions. And if we were in an interactive session, I would be expecting your answers. When was the employment of children under 10 banned and linked to compulsory education? I wonder if any of you have any thoughts. I might jot that down just for yourself to refer, because I can confirm to you that it was 1878, so about 150 years ago. The next question is, when was the school leaving age raised to 16? And that was as late as 1972. These are perhaps interesting facts, but when we look back, we consider how unenlightened our ancestors were. And in years to come, I suspect those looking back at society we'll wonder why it might take us to 2019 to pass the Children Equal Protection from Assault Scotland Act 2019, which removed the defence to smacking of reasonable chastisement. But further back, how many of you remember corporal punishment at school? I recall a very graphic incident at my school where one teacher completely lost control and belted the boy opposite me across the shoulders. Did I say anything? No. Why not? It wasn't until many years later, when speaking with my mother and my brother at dinner, we both recalled the level of physical violence at our school. To say that she was horrified is to put it mildly. So looking to the future, we didn't want that to be the example for our children. Unfortunately, that type of punishment was banned for the independent schools in the Education Act 1980, and also by the Education Act 1993, where corporal punishment was administered, into requirements to come of the European Convention on Human Rights not to be subjected to inhuman or degrading treatment extended to Scotland. So that's a little bit of a historical profile. So look how far we've come. But remember, legislation needs to reflect changing mores or changing times. And there are other ways which I'll come to about trying to think about children, and crucial to all that. And I was interested in Fiona's talk earlier this morning about the role of education. Clearly, we were aware of the curriculum, getting it right for every child, and I'll refer to the school curriculum later on. But I would say that that is a key aspect to think about when we consider about the child and about their rights and responsibilities. So in conclusion to this section, defining a child is challenging and it's fluid. It depends at what time you're talking and at what context you're talking. And interestingly, capacity, obviously in civil to criminal differs. So I want to turn now to the Scottish criminal justice system and what do we mean by it and what do we expect? We as a public expect it to be fair, transparent, and reflect the rule of law. And the rule of law means no one is above the law. So for the law to be effective and for the public to be confident in our fair and democratic society, there must be equality under the law, transparency, an independent judiciary, and access to legal remedy. We must respect justice for all, but it's not a level playing field. Not all people are equal. One size does not fit all. We refer sometimes to the context of vulnerability, and that too is a hard term to define because it, for a child, is complex. What do we understand by vulnerability? Vulnerability changes from time to time. We would probably assess children always as vulnerable within the criminal justice system, as we can see from the legislation such as the Criminal Justice Scotland Act, Section 33, which talks about police interviews and differentiates between children under 16, children that are 16 and 17, and under children hearing referral. So already we're making a distinction in law as to what rights come on and how we're treating them. So is that not inconsistent in the sense that magically at your 16th birthday, you're suddenly much more capable than you were the day before your 16th birthday? Does something magical happen overnight? And I would ask you, how does this square with sentencing decisions to be taken later on? And I'll touch on that briefly at the end. So again, by way of digression, let's think about equality. And interesting, under the Equality Act, child is not a protected characteristic. They fall under age. Does that affect your views or your thoughts? So we understand, obviously, the Scottish Government has a vision for Scotland that states that children's human rights are to be embedded in all aspects of society. Policy, law, and decision-making all are to take account of children's rights, and children should have a voice and be empowered. I would take the key words from this to be proactivity, which you're involved in, you're all very proactive, and looking at solution-based approaches, not at the challenges they offer, but at the solutions and the way we can work together and be proactive to secure our children an investment in their future. So the third section of the talk is 360-degree reflection. I'm sure we're all very familiar with that term. used in appraisal and reviews. But I used it in the context of thinking about the child when I wanted to review their role within the system. And I would suggest that the objectives of 360-degree feedback allows us to increase our self-awareness of the ways in which the child comes into the remit of the criminal justice system. And by examining that, it allows us to promote dialogue, which is what we're doing today, and assess and post a question of how we can improve and go forward. So looking at self-awareness first, I want to look at the child in general. The child can come into the criminal justice system as a victim or a witness, as an accused, or indeed as a convicted person where the issue of sentence is relevant. Before considering these roles, my suggestion is there's a fundamental need for our society to promote first, and that is much more than being merely aware of their rights. Of course, childline is important, and that children should be aware and able to call for help and practical help. But it's not just about that, it's much greater. It's about us who are adults taking responsibility for ensuring children are aware of the intricacies of the Scottish criminal justice system and the responsibilities that citizens hold within that. So it's not just about whether they're breaking the law or indeed about truth and lying, although these concepts are fundamental to the criminal justice system. I would suggest we can take a slightly less developed and sophisticated approach to where I think attention lies. There's a need to raise awareness of their behaviour and impact, which is of course part and parcel of what Police Scotland already do in campaigns such as going into schools and talking about the risk of drugs as part of their drug prevention strategy. And that, the word prevention, it's about stopping them doing things rather than having them doing them and then having to deal with it. And I would illustrate this particular example of education when we look at the Smacking Act. Section 2 set out the duty for Scottish ministers to raise awareness of Section 1, which was the removal of the defence, by taking such steps as they consider appropriate to promote public awareness and understanding about the effect of Section 1. However, to our great disappointment, there was lip service in our view paid to that and little investment made in that aspect of education across the country. Our issues at that time said everyone needed to know about the legislation, its commencement and its significant effects. Because as all of you are aware, cultures treat things like smacking and chastisement in different ways. So the only way would be to make sure that each culture understood what the impact of this legislation is. Because as we all know, ignorance of the law is indeed no excuse. But how can you know what the law is unless you are informed or advised? And so moving on, the corollary is that criminal law must be well advertised to avoid people facing criminal sanctions, not being aware their behaviour is outdated and behaviour that we find unacceptable today in a modern day Scotland. So in passing legislation, it's a bilateral process. Children need to be aware of their rights to be able to enforce the legislation, but those involved with children need to be aware of them as well. Now we can move on to a more recent example. Most of you will be aware of the highly controversial Hate Crime and Public Order Scotland Act 2021 that passed just before the culmination of the last Scottish Parliament. Now it aims at modernising, consolidating and extending existing hate crime law, ensuring it's fit for the 21st century. There's also work currently ongoing under Baroness Kennedy, looking at offences of misogynistic harassment, and look very much at the results of the survey about interference on girls at school and sexual matters. I would suggest that there's a read across there. However, criminal hate crime offences, creating them is only part of the picture. What is better is to avoid any commission of the criminal offences so that the government, when they commence this legislation, make sure that the children are aware of the importance of hate crime. While football partisanship, allegiance and bigotry we might be all united for Euro 2021, is not actually part of the legislation. They very much form, I would suggest, the backdrop in which hate crimes are perpetrated. Ensuring that education embodies the values matters, as shown by the programs which are carried out in relation to sectarianism, that incorporate faith and belief in education, which celebrates difference and diversity, and is aware of the issues of prejudice, discrimination, power, and bigotry. So the power of effective teaching cannot be downplayed. And I recall being involved in understanding that there was a specific pioneering young offenders program targeted at Poland on hate crime and violence. Unfortunately, I can't find the link because I looked for it, but this involved the offenders being taken to Auschwitz in Poland, and they were being taught about hate crime and bigotry. To watch their filmed reaction when they got there could not have been scripted. The emotion was real and very, very moving. It was a very innovative program, I think very interesting, and would benefit being rolled out elsewhere about what actually happens when society gets it so wrong. There are, of course, other forms of education that have seen advice being given to children on what consent and sexual conduct actually means as far as sexual offending. So where does this sit but within the civic school curriculum? I was interested yesterday in the publication of the report on youth strategy because it resonated with much of what I'm saying. The government should help teach children about rights and make sure children's rights are supported. Children find it difficult to understand what happens in the justice system, including at court. Children find it difficult to take part in the justice system. They don't understand justice, it's unfair to them, and they should be taught what justice and a justice system is. So I ask you all today, whose responsibility is that to complete the circle? In other countries, I suggest the studying of civics is mandatory, and that is described as theoretical, political, and practical aspects of citizenships, including rights and duties. It includes the study of civil law and the study of government, looking at the role of citizens, as opposed to external factors such as operation and oversight of government. It prepares people to become knowledgeable and proactive members of a democratic society. So I would suggest that civics, some form of civics, should be embedded in all school curriculum, not just left to those that reach modern studies that might study a form of criminology, because it can teach people about the basis of legislation and how it works. It teaches them about the law and their rights. It teaches them about what is expected and the benefit in their education and understanding as democratic members of society. So my takeaway is, how do you take, how's that to be achieved? How does that fit with avoiding offending and promoting awareness and understanding? And I suggest the responsibility lies with us all. So that was really the child in general sense. The child as a witness. I would suggest that we've moved on significantly from the following incident when justice was served, in my view, but at what cost? At Crown Office, I precognised a murder that happened outside a children's playground on a busy Saturday afternoon. It was a shooting, an assassination. And although we try to avoid our children being witnesses to crime, sometimes children must give evidence in order justice is served. The main witnesses in this case were indeed children of varying ages. I had to interview them all, along with their parents, to ascertain what they'd seen and to assess their ability to give evidence in court. Despite their different ages, their ability, at least in my view, in giving evidence varied, but not in direct relationship to their age. One size did not fit all. How traumatic do we think now, all these years down the line, was this incident for them, this shooting on a sunny Saturday afternoon? Now, pleased to say, I think everything was managed okay, but look at the aspiration now, and that is no child witness should give evidence in court. We can see the use of special measures, commission on and pre-recorded evidence becoming commonplace. And if the recommendations such as Lady Dorian's report on improving management of sexual offences is followed, this will be routine. However, I'd suggest to you this is resourcing, forward planning, training to understand the differences in obtaining and challenging evidence when the witness is not in court, and perhaps a removal from certain people that the attitude of it'll be okay on the day is all right. This is planning and preparation to make sure that the evidence that is given is the best evidence, not only for that child, but for the accused who has a right to the fair trial. Remember the issue of equality of arms. Over lockdown, there have been inevitable winners and losers. The court backlog has built up, and cases involving children as witnesses are a priority. It's going to take time before these work through and resolved. Uncertainty as to when cases will be heard does not help the vulnerability I referred to earlier. However, what the pandemic has done is allowed a focus and development of court technology to allow evidence be taken remotely, while perhaps in an early stage, there is development possible, but I stress not at the expense of the accused or indeed a fair trial. We're aware, and you've no doubt talked a bit, of the government taking forward Barnahus, Bairns House, as it's sometimes called, after Scandinavian models, so that there's a child-centred response for children. There's also the role of adverse childhood effect, which I discuss under sentencing. So my takeaway from this is that we should work together looking at collaboration to avoid the re-traumatization of children and avoid what I also had, which was a 13-year-old child in court being too embarrassed to tell me where she was touched up. She would not do it. The court was closed. We removed her parents, but she would not tell me. Do I think the incident happened? Of course it did. But because she would not tell us where she was touched, it meant that the case failed through no case to answer. I don't want to be in the court again for that to occur. So looking at the child as the accused, no matter what we do, children will end up as the accused. And I'm not going to dwell on this other than to raise the question of the letter of rights, which is given to people detained at the police station. I know the aspiration is indeed not to have children being detained, and that is to be welcomed, but sometimes they will be there. So think about how you communicate effectively to a child at a police station what the rights are. Do you really think that they understand, A, what a solicitor is, that they understand the right to remain silent? And how many of you looking back would understand that yourself? Would you not want to tell your side of the story? It's not fair because it wasn't me, it was her. And indeed, you're there with a responsible adult, parent or guardian, who in your best interest is saying, tell the truth, cooperate. That might be the worst possible course of action. And also think about the bolshy teenager who may find that by speaking out that they're in more trouble, not less. So how do we all going forward ensure that information is made available for these children to ensure that they're adequately protected and understand, and indeed their parents in representing their best interests as well also understand that? So we've obviously moved on with the criminal age going up to 12, and obviously age is important. And I want to touch on the aspect of sciences promoting a better understanding of the brain, which was outlined fully in the Scottish Sentencing Council's consultation last year on sentencing young persons. Sentencing young persons is complex and challenging, and a different approach from sentencing an older person. Account needs to be taken of many factors, including adverse childhood experiences such as trauma and bereavement. And it needs to recognize perhaps a greater capacity for change through rehabilitation. So there was a number of aspects in the covering report because our knowledge of the brain is developing, and many of you here are much better and much more aware of that kind of work. But establishing a clear line between young people and fully mature adults is an issue on which there's a multitude of factors to be taken, and it's very complex. Child defined under 16, age of criminal responsibility 12, under 12 can't be prosecuted, different rules for the children hearing system, different rules indeed for reporting of cases. And the law also gives protections to children under 21 when it comes to sentencing, with, that there needs to be a criminal justice social work report and they can't be sent to an adult prisoner. So as that research develops, there is increasing evidence that the brain may not be developed until at least the age of 25, and that there are different stages of that brain development. I hope that these aspects are all ones that we can look at developing, so we become enlightened and treat our children as they require to be dealt with, and we do what we can to improve their lot, so to speak, within the Scottish criminal justice system. I think we're just coming up to time, and I hope this canter around the criminal justice system and looking at the child perhaps in a slightly different way, in the 360-degree involvement in the criminal justice system, has provided some background for you. It's probably some repetition and knowledge that you already have, but hopefully there's some insights and thoughts to go ahead. Remember, it's not just for the lawyers to draft and implement legislation that is, through policy considerations. It's about all of you in your different disciplines working for and with children to promote and encourage change. And I'd leave you with Nelson Mandela, that said, there can be no keener revelation of a society's soul than the one in which it treats its children. Well, let's all grab that responsibility and ensure our children are treated fairly and appropriately, and that our criminal justice system benefits from when they become not of their choice necessarily involved within the same. Thank you very much for your attention.
Oh, thank you, Gillian. What a lot of ground you have just covered there. And I'm just reading the chat. Your mention of police officers in schools has certainly got a lot of discussion going on that you could maybe have a wee look at after. There has been a few questions coming through, and if there's any more, you've got a few minutes to send them to me while Gillian thinks of her answers for the first ones. Gillian, I think one of the main questions that has been asked, and something we'd all like to know, is how are we preparing for the UNCRC into Scottish legislation? And is the Law Society considering any amendments that will ensure Scots law is compatible with the UNCRC?
Well, unfortunately, I'm not the best person to answer that, because that was very much taken down the civil route under one of my colleagues, Michael Clancy. What I would say is that the Law Society was very heavily involved in briefing at all stages, and that is available on the Law Society of Scotland's website. I know that there was a challenge taken at the UK Parliament, which was being dealt with by my colleague, but I can confirm that we have a range of committees at the Law Society, and the Child and Young Family Law Committee was mainly responsible. So because it didn't really touch on to criminal, which is very much my parameters, I was involved peripherally. But yes, I'm happy to forward on to you, Fiona. It's on the main website under influencing policy. You can see what's said, but clearly Law Society very much proactive. And this question of human rights being embodied is something that we're seeing obviously from the government. And interestingly, in the new Justice Parliament, you can see that they are splitting the justice. Criminal is going one way, with civil, family, and all the others, human rights and equality, going to a different committee. And that maybe says something about the raft of criminal legislation to come, but it also maybe says where they want to centre this focus with rights, equalities, etc. So not quite an answer, Fiona, but perhaps that's perhaps a bit supportive, definitely, because human rights obviously underpins everything, and there'd be a major concern if these human rights weren't, are not fully embedded in everything we do.
Mm-hmm. Thank you. There's been a few questions coming through, I think, about the age of criminal responsibility and the knowledge of brain development. So in relation to that, what do you think, and what's your view the age of criminal responsibility should be in Scotland?
Well, this is very interesting, because we are very much proactively, I was involved indeed in that bill, so that's easier in a way, but very much supported the 12 years. We can very much see that across Europe in comparative studies is obviously different ages. And I think this is what I was trying to hint at when you see sentencing guidelines coming through, talking about this developing science, this emerging science that we get to know. I like the fact that towards the end, there was indeed this move to move it to higher. I certainly was more than happy to be guided and supported by the experts that would say, actually, it'd be better at 14. And I was pleased when there was such a move that there was this buy-in. The government obviously had to look at it again and look at it again very quickly. I think it's important to recognise where we've come from, that to move from 8 to 12 is quite a dramatic change. And I think the difficulty, as we all know, you were talking earlier before the conference started about, I was quite interested in your experiences of COVID and all your children at different levels at school. I don't have that experience because, in fact, I've just become a grandmother for the first time, but I can remember the thoughts of, goodness me, my older and younger child. Now, my younger child was born the same age as her big brother, didn't believe there was any difference, took responsibility, and was quite a different child. And whereas her brother was completely horrendous, completely irresponsible, and was probably acting 3 years younger. So the trouble is that the criminal justice system pigeonholes. And that's really the point I was getting at about how you define a child, because you've got to have a cutoff point. And although I flagged the 16 for the different rights at the police station, I think it's important that we remember that it is a case of magic change. On their 16th birthday, they are a different person. And yet, have they changed overnight? No. I think what you need is everybody to be aware. So probably greater knowledge and understanding of the emerging science that develops different stages, and relying on people such as yourself, Fiona, the experts in the field that actually have much greater knowledge of how that is all panning out. And that's in a way why I put it against the historical challenges of our Victorian predecessors, who would be horrified to see our children out in a school playground playing at 18 and not up, or down the mines probably. We've moved on. So that's why what would we like to think somebody in 30 years' time is going to look back and say, well, we got rid of smacking, and that's quite polarized. But I did mention the corporal punishment because this was the 1970s, and it's still, that incident actually is really quite fresh in my mind. I was absolutely terrified. But the school, it didn't happen to the girls, it was just the boys. But the level of violence was something clearly should have been prosecuted. So we change, is what I think. Does that help?
Definitely, I suppose, and two sides to that, I suppose, especially for our children and young people who can end up in our justice system, like you'll be aware, it's the developmental age is so important. And we know 60 or 70% have speech, language and communication needs, yet we just focus on the numerical age and don't seem to take that into account. It's definitely something for us to consider. Got a couple more questions, Gillian. One thing, if you've got the time, was how do we prepare society then for our children's future? You said it's up to us to prepare. How do we do that? And then there is some questions. There's a lot about how do we influence the school curriculum then, and who's best to do that? We've got a lot of the chat. Is it the police? Is it paramedics? Is it lived experience? Young people going in? Is it educating teachers? What's the best way to do that? So it's two questions, one about the school and then one about society before we finish.
Okay, I think taking the influence in the school, that's where we were disappointed with something like the smacking, because we thought that we are increasingly always moving in legislation to try and get raising awareness, public knowledge of all these criminal bills because of the importance of criminal law. I fundamentally think in England, for instance, you can study law at school. You can't really in Scotland. And also that would be appropriate for the majority of children don't want to study law. I think somewhere along the line, whether you call it democracy, civics is the American term, I think there's a fundamental requirement for it to be embedded as part of the curriculum. The school curriculum is set obviously by the government at the time, but there needs to be some kind of responsibility in society put onto the schools clearly, and that's the school. So I would say that's government, and that would factor in everybody, everybody that's involved in the kind of areas that would need to be embedded and taught as part of formal school education. But of course, there's responsibilities in society. So you come into contact with your children, you teach them right and wrong. You also might allow them to watch television, to watch
courtroom dramas or things, or you might actually tease out their interests because you are responsible parents. There is that rule of right and wrong, but also perhaps to make them familiar with the justice system. After all, you may require to give evidence yourself, you may be involved in an incident, you may be involved professionally, not making it a secret, but trying to make it part of every day, or there's open days at courts and things like that. Having that opportunity to say there is a justice system and this is what it does would be, I think, one thing from responsible parents, but we don't all have responsible parents. So I would say in certain cultures, and that again comes back to smacking, because we were so aware that there was a polarized view in the Law Society of people that were diametrically opposite as to whether they supported the ban or not. I was quite happy because I thought the law required clarification, so I didn't need to take sides. But so one of my colleagues was very much of a particular family persuasion that, it didn't do any harm. And that was my concern, because in that culture where it doesn't do any harm, then you are promoting that understanding from these children that actually this is the way to do it. It's about watching and copying what we do. Now, none of us are perfect. We've all done things that we probably shouldn't have done. So it's a responsibility for us in society at every stage we interact. So if you take Scouts, you take Brownies, Rainbows, you are involved with children. You've got an opportunity to influence. But I think, firstly, I would say for government to recognise that every piece of criminal legislation, or indeed civil if it affects children, should actually be looked at to see how you bring it to people's attention. Because if they don't know, it's no good, particularly with hatred and things like that. That starts in the school playground with the straightforward fight of football teams. And we know that happens. So I think curriculum, does need to change in a more formal way, that it's part of that. But as well as that, there's a responsibility for us as adults in our relationships with children and cultures, and to hit out at areas where perhaps they don't benefit from as much exposure because of poverty or whatever, to try and bring that equality up. Does that help?
Yes, definitely. There's one last quick question that's just come in saying, is there an argument to extend special measures to young people engaged with the criminal justice system when they are there as a suspected perpetrator, not as a victim?
What an excellent question. The answer quite straightforwardly is yes. Why would the accused be any different? And this is interesting because some of you may be aware that the Law Society did 2 years ago now quite a lot of work on the vulnerable accused. And I think there was certainly someone from the youth side at that. Now, we were expecting to continue that work, but the pandemic hit us, so we didn't. But that was one of the key points, because we know from some of the members that are doing criminal defence work, we know that, they've tried to move that particular thing or to get support for the accused, and indeed not been particularly well received by the sheriff. Better at high court level. I think when you get to the more serious, the judges are probably more enlightened, and they've had psychologists or psychiatrist reports to try and help. But absolutely, if you've got equality, it's got to extend to the accused. Why would we be barbaric enough to say the accused who's suffering necessarily has to sit in the dock in the court staring at all these people? Now, 20 years ago, when I was involved in the justice system, we, definitely, if there were children, off came the judge's wig, off came the gowns, we took gowns off and we sat and asked questions. It's still very formal, but it was, obviously marginally better. But I think we've moved on from there. And, if you don't have the measures for the accused who needs them, is that fair? It's not fair. So needs greater recognition, and that perhaps leads to judicial education, as I did hint at. Perhaps greater use of special measures means better planning by solicitors in both the Crown and Defence side, and the awareness of impact. So I did flag that my own profession perhaps has sometimes somewhere to come, to come some distance too. But I think we recognise that the child, just as all these quotes said, is so important. But I think that's an excellent question. Thank you for it.
Yeah, and just I guess on that as well, just, and mentioned the Barnahouse model, should children accused be included in that, in your view?
Interesting. I haven't, unfortunately, when Barnahouse was introduced, it then got impacted immediately by the pandemic. So I haven't actually seen the suite, because my chief executive did, but I hadn't. So I've yet to see where it is, but clearly things should be I mean, there is an argument, you've done a crime, therefore you should suffer. I think that's gone out with the arc, and therefore, how do we make it easiest and best for the child to be, who has offended, to face justice? And what can we do to make it better? If that means that you have elements of Barnhouse or pre-recorded evidence may be appropriate. The difficulty there is, of course, you need to know what all the other witnesses have said first before you can pre-record. So there are timing issues, but it would be interesting, I think, Fiona, to look back in, 20 years' time? Perhaps we could take a note and look back and say, how's the child seen in the Scottish justice system? But I think it's also important we don't berate ourselves, because a lot of you will be on the international perspective or European perspective. Are the other countries doing that much better? We can look to Europe in an inquisitorial system, which I would think we don't have such direct comparison with, but we can look at other common law countries such as America, obviously, and see they've got specialist courts. We have specialist courts. We're obviously going to specialize in probably sex offences courts. It'll be interesting to see just where the child kind of idea of the courts goes, but that tends to lie down, obviously, the children's hearings, which wasn't something I was myself involved. I think I've only done about one prosecution of a child under 16.
Oh, Gillian, thank you so much. I'm going to repeat what Bruce said just if we were sitting in the Stirling Court Hotel, I think people would be giving you a standing ovation just now. But thank you so much for your presentation today, and do have a look on the chat, because there's lots of feedback there and lots of interest and just discussion. But on behalf of us all, thank you so much.
Thank you very much for inviting me. Thank you.
Thank you.